The issue of consent in marriage remains a deeply sensitive and often misunderstood topic in Jamaica. In present time, many hold the notion that their partner is their property, and as such, things like having sex, even without consent, shouldn't be a problem. In this week's edition of Query This, Chantae McNeil explores whether a married spouse can be charged with rape and what legal protections exist for victims.
This. You've been living with your husband for years. He comes home one night in the mood for intimacy, but you clearly aren't aroused, and share with him that you're not interested. However, he insists that you are his wife and he has a right to sexual pleasure whenever he likes and forces himself onto you. Is this action justified? Is marriage a blanket consent to sex? Is it even possible to be raped by your husband? Here's some of your views.
Just because you're married doesn't mean that he has a say over your body. He's your husband, not your slave owner.
He want to be satisfaction because that's why I'm married to her. Because if he don't want anything outside the road, he wouldn't come to that person. So if you believe in another right way, you're married to a man for the personal purpose, just work with it. And God will bless you.
No, because if someone feel it's supposed to get easy. 24 hours, don't. Anytime you can get it, just wait me for the man before you go work or something, you can get it then time then.
I think he should have a free pass. The reason being, I believe the wife should be submissive. Even if she's not in a mood, right? She can just go so boom boom, turn around and, a quick little risk. A husband and wife, so you're supposed to be like submissive to your husband. Help him out and move on.
No, I said no, so you have to respect my, choice or whatever, so.
Strong opinions, divided perspectives. But what does Jamaica's law actually say? Under Section 5 of the Sexual Offences Act, an outline is given as to what constitutes rape in marriage. We visited attorney at law Michelle Thomas, who broke those down.
You have to be placed under certain specified circumstances, and there are only 4. So whether or not the person is separated within the meaning of the Marriage Cohabitation Act, no, that's Matrimonial Cohabitation Act, that is. If it is that you are divorced or going through a proceedings of divorce or a nullity of marriage, whether or not there is an injunction or a court order that prohibits the husband from being in the same vicinity as the wife, and if it is that the husband knowingly has STD and cause to have sexual intercourse, then it would be considered rape.
So in a case where a woman was forced by her husband into sexual activity and later contracts a sexually transmitted disease, Thomas outlined her legal recourse.
She will have the recourse of going to the police station, making a complaint. The police will then launch an investigation and charge the husband accordingly. He would be charged based on in contravention of Section 5 and the relevant subsection because of the fact that he knowingly have sex with Sarah, who has STD, and has caused her to have the STD or forced himself on her in a sexual manner. That would be considered as rape in that category.
Despite this, there's no blanket legal recourse in the Sexual Offences Act for all forms of non-consensual sex in marriage. And for many, especially women, they've called for it to be amended to facilitate the rights of their bodies. If you're facing a family dispute, legal issue with a neighbor, business, or employer, there are laws that may protect you. And I'll help you explore them. Email me at cmcneil@cvmtv.com and I'll help you navigate the law. Until next time, I'm Chantae McNeil.